If you saw headlines saying the Supreme Court just dropped an emergency order that wipes out restrictive carry maps across America, stop right there. Because if you believe that too fast, you could make a bad carry decision today. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to clear up could keep you from trusting the wrong headline at the worst possible moment. Hit that button now, because gun law confusion is exactly how good people end up in bad cases. Here's what just happened, and here's what did not happen. The real case you need to know is Wolford v. Lopez. That is the Supreme Court case about Hawaii's rule that can make it a crime for a licensed person to carry on private property open to the public unless the owner says yes first. Think stores, restaurants, shopping areas, and other places where regular people go every day. Now, here's the first thing most people get wrong. The Supreme Court has not, as of right now, issued a final nationwide decision ending those restrictions everywhere. That did not happen. There was no magic one-page order that suddenly erased carry maps in all 50 states. And if you act like there was, you could be the one paying for that mistake. What did happen is still a very big deal. The court agreed to hear the Hawaii case. Oral argument happened. And the justices looked seriously at whether a state can flip the normal rule and say, no guns on private property unless the owner gives express permission. That matters because Hawaii is not alone. Similar rules showed up in places like California, Maryland, New York, and New Jersey after the Bruin decision. Let me break that down for you in plain English. Back in 2022, the Supreme Court decided Bruin. That case said, New York could not force regular citizens to prove some special need before getting a carry permit. In simple terms, the court said the Second Amendment protects carrying a handgun in public for self-defense, not just keeping one at home. So what happened next? Several states looked at Bruin and said, fine, if we can't block permits that way, we'll tighten the places where people can carry. That is where these so-called carry maps exploded. Suddenly, whole chunks of normal daily life started getting labeled off limits. Parks, beaches, bars, some entertainment areas, and in some states, a huge amount of private property open to the public. That is why people use the phrase restrictive carry maps. They are talking about a patchwork of laws that can turn your normal day into a legal maze. Imagine this. You leave home with your permit, you stop for coffee, then gas, then lunch, then you meet your wife at a store, then you drop cash at an ATM on the way home. Most people think, if I have a valid permit, I'm good. But the truth is, in some states, the answer depends on exactly where you step, what signs are posted, whether the property is public or private, and whether the law assumes carry is allowed or banned by default. That default rule is the heart of this fight. In most places, the normal rule has been simple. If a business owner does not want guns inside, they can say so. They can post a sign. They can tell you to leave. But these newer laws flip that around. They say the default is no carry unless the owner has clearly allowed it. But here's the crazy part. For a person trying to follow the law, that flip can matter more than the permit itself. Because now your question is not just, do I have a permit? Your question becomes, did this business owner give express permission, and does state law require that permission before I even walk in? That is a totally different world. And this is the part that shocked me. A lot of online commentary makes it sound like the Supreme Court already swept all that away. No, not yet. The case is huge. The stakes are huge. But today, you still have to follow the law where you stand. Second, let's talk about the word emergency, because this is where people get sucked in. When most viewers hear emergency Supreme Court decision, they think the justices jumped in fast and changed the law overnight. Sometimes the court does handle emergency requests. But in the carry context, the big example people keep mixing up is New York. After Bruin, New York passed the Concealed Carry Improvement Act. Gun owners challenged it. Parts of the law got blocked by a lower court. Then that changed on appeal. The challengers ran to the Supreme Court asking for emergency help. And what happened? The Supreme Court did not grant that emergency relief. The court let New York keep enforcing the law for the time being while the case moved forward. Justice Alito, joined by Justice Thomas, basically said the denial should not be treated like approval of New York's law, and challengers could come back if the lower court dragged its feet. That is important. But it was not a nationwide win for carry rights, and it was not a nationwide loss either. It was the court saying, not now, keep litigating. That distinction matters more than most people realize. Because there are really three different things people mash together online. First, a final Supreme Court ruling after full review. Second, an emergency order during fast-moving litigation. Third, a procedural move that sounds dramatic but does not settle the issue. Here's a hypothetical example to explain this. Let's say a lower court upholds a carry restriction. The challengers ask the Supreme Court to step in immediately. If the court says no, that does not automatically mean the justices think the law is perfect. It may only mean they are not stepping in at that stage. Now, this is where it gets interesting. In the New York fight, there was another later move that confused people even more. In Antoniuk v. James, the Supreme Court granted the petition, vacated the lower ruling, and sent it back for another look after the Rahimi case. That sounds massive, right? But wait, there's something even more important. That kind of move is procedural. It does not mean the justices issued a final opinion wiping out the law. It means, look at this again using the newer guidance. That is why you have to be careful with flashy titles. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police ask about your gun. Subscribe so you don't miss it, because the smallest legal detail is often the one that saves you. Third, let me explain why Wolford could still become the biggest carry locations case since Bruin. The case focuses on Hawaii, but the ripple effect could go far beyond Hawaii. Why? Because the basic question is simple and huge at the same time. Can a state presume that private property open to the public is off limits for licensed carry? Unless the owner says yes? That sounds narrow. It is not narrow. Think about your daily life. Grocery stores are private property. Gas stations are private property. Restaurants are private property. Most shops are private property. So if a state gets to say all of those places are automatically no carry unless the owner opts in, your right to carry in public can shrink fast. That is exactly what challengers argue. They say the right becomes almost fake if the places people actually go are closed off by default. Supporters of these laws say something very different. They say private property owners have rights too. They say the state can protect those owners by making the default rule no firearms unless permission is given. In other words, they frame it as a property rights rule, not just a gun rule. See the tension? Most people think this is only about the Second Amendment. But the other side says this is also about who gets to set the rules on private land. And that is why the justices took the case seriously. At argument, the fight was not really about whether a business owner can ban guns. Of course, an owner can choose that in many situations. The real fight is over who gets the default advantage. Is it the carrier, unless the owner says no? Or is it the owner, unless the owner says yes? That one switch changes everything. Here's what most people get wrong. They think if the Supreme Court rules against Hawaii, every carry restriction in every blue state disappears instantly. Not true. Even a strong ruling would most likely answer a specific question. Other restrictions, especially sensitive place rules, would still be fought, case by case. So if you are waiting for one decision to make every carry map easy, don't hold your breath. Fourth, let's talk about why this matters to you right now before any final opinion comes down. Because confusion is dangerous. Imagine you're driving through a state with a permit that is valid there. You check a map online, it shows reciprocity, so you think you're covered. But the map does not clearly explain a private property default rule, a local sensitive place rule, or a rule about posted signs. You stop at a restaurant. You carry inside. Then something happens. Maybe nothing criminal. Maybe just an argument. Maybe police get called. Now what should have been a normal meal turns into a legal event. That is how ordinary people get trapped. Not because they are evil, not because they meant harm, but because the law is not simple and bad summaries spread faster than the truth. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Fifth, here's the part nobody's talking about. Enough. Even if the court eventually strikes down Hawaii's default rule, that does not mean you should ignore every posted sign, every restricted area, or every local carry rule the next morning. Court decisions take time to work through lower courts. Some rulings are narrow, some states rewrite laws fast. Some agencies issue guidance. Some police departments change training slower than you think. So what should you do? First thing, verify the actual ruling, not a thumbnail. Second, read what question the court actually answered. Third, check whether your own state has a separate law that was not directly decided. Fourth, if you travel, check the destination state that same day. Not last month, not from memory, that same day. Fifth, understand the difference between a permit map and a places you cannot carry map. Those are not the same thing. This is the part that really gets people. A reciprocity map tells you whether a state recognizes your permit. It does not always tell you every location restriction that can still get you charged. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want the facts before the rumors. Click subscribe and stay ahead of the next ruling instead of chasing it after the damage is done. Sixth, let's get practical. What are the safest takeaways right now? Number one, do not assume there has been a nationwide emergency win on restrictive carry maps. There has not. Number two, the Supreme Court's current big carry locations case is real and it is important. Number 3, the final outcome could affect states that copied the same kind of private property default rule. Number 4, until a final ruling arrives and lower courts sort it out, your current state law still matters. Number 5, don't make this mistake. Do not use internet confidence as a legal defense. If an officer asks why you thought you could carry there, I saw a guy on YouTube say the Supreme Court ended all carry maps is not going to save you. Let me say that again, because it matters. A loud headline is not legal protection. A viral clip is not legal protection. A screenshot from 6 months ago is not legal protection. Your best protection is current law, careful reading, and knowing exactly what state you're standing in. And if the court does rule against Hawaii later, I'll tell you right now what the smart move will be. Slow down, read the actual holding. Find out if it covers only private property open to the public or more than that. Watch how New York, California, Maryland, and New Jersey respond. Because those states are not going to just shrug and say, well, that's that. They will fight over wording, scope, and replacement laws. That means the real battle may not end with the opinion. In some ways, it may begin there. This information could literally change again before the next term is over. Subscribe now, because the next video explains exactly what to watch for the day a carry ruling drops, and what steps you should take before trusting any so-called update. So here's the bottom line. The urgent part is real, but the emergency nationwide win headline is not. The Supreme Court is looking hard at whether states can use these restrictive private property carry rules, and that could become a major turning point. But today, you still need to follow the law that applies where you are standing, not the law people wish had already happened. Pause. If this kind of straight answer helps you cut through the noise, subscribe right now and stick with this channel. I know this stuff can feel confusing and even a little scary, but you do not have to figure it out alone. I'll keep tracking the real cases, the real rulings, and the real deadlines so you can protect your rights without stepping into a trap. And one last simple disclaimer. This video is for education only. It is not legal advice, and it is not a substitute for talking to a qualified attorney in your state about your exact situation. GitHub.